And so what's up guys, welcome back to our channel. Today's news. Nnamdi Kanu files objection challenging Nigeria court's jurisdiction to try him. The detained leader of the indigenous people of Biafra, Nnamdi Kanu, has filed a preliminary objection before the Federal High Court sitting in Abuja, challenging the court's jurisdiction to try him. Kanu, in the notice of preliminary objection to jurisdiction of the court filed on Monday through his legal team led by his special counsel, Barrister Aloy Ejumakor, told the court that it has no jurisdiction to try him, stressing that charges filed against him before the court by the Nigerian government are unconstitutional. Kanu filed the notice of preliminary objection on the strength of sections: Section 1, Subsection 3, Section 6, Subsection 6, Section 12, Section 30, Subsection 2, Section 30, Subsection 8, Section 42, Section 45, and Section 251, Subsection 1Q of the Constitution of the Federal Republic of Nigeria 1999 as amended. Section 178 of the Custom and Excise Management Act as repealed, Section 218, Subsection 1 and Subsection 2, and Section 220 of the Administration of Criminal Justice Act 2015, the Terrorism Prevention and Amendment Act 2013, and under the inherent jurisdiction of the court. He said that the court has no jurisdiction to try him on counts 1, 2, 4, 5, and 8 on the points and authorities to the extent that the provision of the Terrorism Prevention and Amendment Act 2013 enabled the Nigerian government to determine questions arising in administration of Terrorism Prevention and Amendment Act, which led to the expert order of proscription of IPOB and its declaration as a terrorist group, and the gazetting of such order without giving the applicant an opportunity to make representation to the authority is void for being inconsistent with the provision of Section 36, Subsection 2 of Constitution of the Federal Republic of Nigeria 1999. The legal team said that Section 32, Subsection 2 of the Constitution provides, without prejudice to the foregoing provision of this section, a law shall not be invalidated by reasons only that it confers on any government or authority power to determine questions arising in the administration of a law that affects or may affect the civil rights and obligation of any person if such law A. provides for an opportunity for the persons whose rights and obligation may be affected to make representation by the administrating authority before that authority makes the decision affecting that person, and B. contains no provision making the determination of the administering authority final and conclusive. The IPOB leader praised the court for an order of his honorable court declined jurisdiction to entertain counts 1, 2, 3, 4, 5, and 8 of the charges against the defendant or applicant, or to squash said counts on the ground that the law upon which said counts are predicated is unconstitutional, and law under which applicant is being tried in this court has otherwise been repealed. An order of this honorable court declining jurisdiction to entertaining count 3 of the charges against the defendant or applicant, or to squash said count on the ground that the said count is unconstitutional. It is not supported by proof of evidence and is otherwise an abuse of process. Wow. Interesting. An order of this honorable count declining jurisdiction to entertain counts 1, 2, 4, 5, and 8 of the charges against the defendant or applicant, or to squash said counts on the ground that the applicant is missed by the absence of or the failure to state the place of commission of the alleged offences and the specific dates of the procats alleged. An order of this honorable court declining jurisdiction to entertain count 15 of the charges, or to squash said count on the ground that the said count is not in compliance with the Administration of Criminal Justice Act, is not within the territorial jurisdiction of this honorable court, and is not supported by any proof of evidence, and law under which applicant is being tried in this court has otherwise been repealed. And for such further orders as this honorable court may deem fit to make in the court circumstance. The plenary objection of the court's jurisdiction was sequel to the ruling by Justice Binta Nyako of the Federal High Court in Abuja on Monday afternoon, where she dismissed Kanu's fresh application seeking the restoration of his revoked bail and his removal from the DSS custody to a house arrest or prison custody. Sahara reporters had reported that the judges who dismissed the applicants for lacking in merits, said that Kanu had brought the same applicant's application before the court. Despite the Supreme Court's ruling in 2023 that Kanu did not jump bail, Justice Nyako said that she found as a fact that the IPOB leader jumped the bail granted to him earlier and that he escaped out of Nigeria. Justice Nyako further ruled that the shorties who stood for Kanu in the earlier bill had applied to be discharged and had been discharged on the ground that they could not locate Kanu and did not know his whereabouts. The judge held that the only option left for Kanu was to go to Court of Appeal and should proceed to the appellate court to exercise his rights of appeal. Nyako disagreed with Kanu's lead counsel that the Supreme Court held that the earlier bill granted him ought not to have been revoked, saying that she had pursued the Supreme Court judgment copy and did not see the claims by Kanu's lawyer. Reacting to the judge's ruling, Kanu blasted the Nigerian government for violating the provision of terrorism, prevented and prohibited acts by seeking to try him, saying that Nigerian court seeking to try him is an act of terrorism. Wow, it's getting interesting. In the preliminary objection notice, the IPOB leaders' legal team further asked the court to take notice that at the hearing of the preliminary option, the defendant shall, in addition to the affidavit, exhibits and the written address filed before it, rely on the following grounds. Regarding counts 1, 2, 3, 4, 5, and 8, the provision of the Terrorism Prevention Act 2011 as amended in 2013, under which the IPOB was proscribed and declared a terrorist group, are inconsistent with the provision of the Nigerian Council and are thus void to the extent of the inconsistency. Regarding counts 1, 2, 3, 4, and 5, and 8, there is a subsisting judgment of a high court to the effect that the executive action leading to the declaration of IPOB as a terrorist group and its prosecution is unconstitutional. Regarding counts 1, 2, 3, 4, 5, and 8, there are two international tribunal decisions against the arrest, detention, prosecution, and trial of the applicants, which are, by virtue of the provisions of the Nigerian Constitution, binding on the complainant and this honorable court. Count 3 of the charges against the defendant or applicant is unconstitutional, as it seeks to punish the applicant for an act that was not a crime when it occurred and is otherwise an abuse of process. The law under which applicant is being tried in court 1, 2, 4, and 5, and 8 has been repealed. Count 1, 2, 3, 4, 5, and 8 are incurable defective as the applicant is misled by the failure to state the place or where the alleged offences were committed by the specific dates of the alleged broadcast. Count 16 is not in compliance with the Administration of Criminal Justice Act. It is not within the territorial jurisdiction of this honorable count and is not supported by any proof of evidence, and law under which applicant is being tried in this court has otherwise been repealed. There are some feedback on this post. MK rectoring the Nigerian judiciary and the entire zoological republic. Indeed, Nigeria is a zoological contraption. Wow. But this is what IPOB opted for initially, but wanted to prove how wonderful he was. Now that he has hit the rock, he is coming back to what should have been first. After another reply. After all this, many of you will still come out to castigate the legal team, saying they don't know what they are doing, instead of preferring suggestions and ideas to help them get MNK, which is Nnamdi Kanu, regain his freedom. His freedom is more important to us than all this backbiting. Indeed, his freedom is our priority. The notice noted that this honorable court has the constitutional vice and the inherent jurisdiction to interpret the Constitution and the laws of the Federation of Nigeria.